Hello everyone and welcome to today's webinar. We have a great session lined up for you today. Before we get started, there are just a few general housekeeping points to cover. First and foremost, if you have any questions, please use the online question tool to post any questions that you have, and we will share them with our speakers. Second, if you experience any technical difficulties today, please use the same question tool and a member of our admin team will be on hand to support you. And finally, just to note, this session is being recorded and we will be sharing a copy of the recording with you via email in the coming days. So without further ado, I'd like to hand over to Tim Hickman to get us started.
Thank you, Sandra. Hi, everybody, and welcome to today's webinar entitled Data Protection, a Practical Approach in a Time of Uncertainty. I'm sure many of you will have looked at that title and gone, Tim, is there ever a practical approach to data protection? And I appreciate the answer is often no, but today we're going to try and get you there. We're delighted to be joined today by Emma Bate, who is Director of Data Privacy Advice and CNC at the Information Commissioner's Office. I'm also joined by John Timmins, who is a partner in our London data protection team. And my name is Tim Hickman. I run the data privacy and cybersecurity team at White & Case. As you all know, today we are going to try and talk about all things data protection and what's going on in the UK right now. If you have questions, as Sandra said, please do submit them in the chat. And what we'll do as we go through is I will keep an eye on the questions, and then we've got time allotted at the end for Q&A, where I will then put your questions to John and Emma. So if you feel like a question's not being answered at the time, don't worry, I am keeping an eye on it, and we will try and cover as many questions as we possibly can. So with no further ado, I am delighted to hand over to Emma. Please go ahead.
Thanks, Tim, and good morning, everybody. So my name's Emma Bate. I'm a legal director, and my area of responsibility is on the legal advice side in relation to data protection. And you may wonder what CNC is, but that's our contracts and compliance team. So I also oversee the legal advice given internally to the ICO. And so, of course, that covers our own international transfers. I've been heavily involved in the ICO's international transfers work. I can't even think for how long, maybe like 4 or 5 years, and have sort of, I'm there at the forefront thinking about the documents that we produce, the guidance we give, and also in our external role. So today, what I thought would be useful for you would be to take you through just 3 things. First of all, the role of the ICO in international transfers, to give you a better understanding of what we do and what we're doing to try and help you. Some practical steps that I've put together based on my experience working in private practice as a lawyer on international transfers, and then of course in the ICO. And then finally, some fresh thoughts on transfers to the US and how to carry out a transfer risk assessment given the recent data breach to the US data protection framework. More on that when we get to it. Next slide, please, Tim. So this is a quick overview of the role of the ICO in the world of international transfers. So of course, we provide guidance, and in data protection, which sort of links to what Tim was saying, is that it's such, when you read the legislation, it's so complex that actually the ICO guidance is a really important part of our role and a really important part of promoting compliance with data protection practices. And remember, it's not just for large businesses. We also are giving guidance to the very smallest of businesses, just a sole trader. They also rely on our guidance, so we have to write our guidance with that in mind. But then we get onto the sort of the more technical part of our role in international transfers. So when the UK government is looking at legislating for a new data breach, a new adequacy decision in relation to a country, we play a pivotal role in that. We will provide advice and guidance as a critical friend all the way through the process. And then at the end, we will give advice to the Secretary of State on the final piece of legislation and the final assessment. And we will also do an opinion to Parliament because obviously the adequacy regulations need to go through that parliamentary process. And you can find all those opinions and advice are both published. We also have a responsibility alongside the Secretary of State to issue and publish Article 46 transfer mechanisms, and so far we've issued 2, the International Data Transfer Agreement, the IDTA, and an addendum to the EU SECs. We have a role in approving BCRs, and if you are interested in the world of BCRs, you may have heard that we are about to publish, it's any day now really, a new UK addendum to the EU BCRs to try and make that process more straightforward for businesses who have an approved EU BCR. And if anyone has any questions on that, you can ask me at the end. We have a role in approving codes and certs for transfers and bespoke transfer contracts, but actually I don't think we've had any to approve as yet. And then finally, we have a role in authorising administrative arrangements, or MOUs, between public authorities. And again, we have very few, but we do have one of those at the moment. Next slide. We also play a role globally in the world of cross-border transfers, where the focus seems to now be on something called DFFT. I don't know if that word has come across your desks, but it's data free flow with trust. It's sort of the latest buzzword on how to improve cross-border transfers. And with that in mind, there are sort of 3 key areas which we've been working on. First of all, there's the global CBPR forum, and CBPR is a certification scheme which works internationally. It started in the Asia Pacific, but is now expanding, and the UK's an associate member of that. So we're watching it and talking about it, but we're not yet signed up to CBPRs. We worked with DCIT in the Council of Europe in their production of new model contract clauses. It's DCIT that's got the seat at the table at the Council of Europe, and we advise DCIT on what to say. And then we're also co-chairing, it's myself that's co-chairing this GPA working group on DFFT, and actually we've got another meeting on that this afternoon, and that's a group of the G7 regulators talking about DFFT and what steps we can take to improve DFFT. So moving on to our 6 practical steps. As I said, this is from my own knowledge of working as a data protection lawyer, but also then in working at the ICO and producing the guidance. And I'll just get stuck in straight away into our first practical step. If we can go to the next slide, please, Tim. Which is the first question you should ask yourself before you make a cross-border transfer, is whether you can reduce the amount of data sent. It is probably a good regulator's point in that it doesn't, I know often the business people will be saying, no, you can't reduce the amount of data, but it does make everything a lot easier, the less data you send, and it makes everything simpler. So it is worthwhile trying to have a think about it. I've also suggested you avoid free text boxes, because obviously if you have a free text box, then you have to assume that, unless there are very strict rules about it, that people will put all kinds of things in there that they shouldn't. So the next practical step is to do the assessment first about how risky is the data that you're sending. So you don't need to do this at this point if you're following, if you're using the addendum or the IDTA, and if you're doing a TRA, but I think that this is the best time to do it right at the start, because then you can make decisions that are reasonable and proportionate based on your knowledge of how risky the data is that you're sending. In our TRA tool, we've got a table which gives you an initial risk score as to whether something is low, medium or high harm risk. And don't forget our ICO bespoke taxonomy for data protection risks, which is available on the website. that's a really helpful document. And actually, I mentioned it in a webinar recently, and a friend of mine who's a data protection lawyer hadn't come across it before, and she was like, what is this? So if it is something you've not seen before, go and have a look at it. I didn't write it. It's been written by our economists team, and it's really helpful. So moving on to our next risk is the first question, not the first question, the third question you should ask is there a restricted transfer at all? So if you go back to the ICO guidance, our guidance sets out that the restricted transfer basically follows the contract. So if you are contracting, if your service provider is another UK entity, there will not be a restricted transfer. Of course, that service provider may be making a load of cross-border restricted transfers as a part of the next stage. And this is quite often the case with cloud services. You'll find that your cloud service provider is a UK entity, so you are not making the restricted transfer, but the cloud service provider will be making lots of restricted transfers. So first of all, ask yourself that question. So on to our next practical step. So even if, whether or not there is a restricted transfer, you still need to do some due diligence, just as a controller sharing data with another controller or processor. And one of the reasons why it's a good idea to think about how risky your data is in the first place is that goes to the heart of what's proportionate and reasonable in the checks that you have to make. So it's thinking about the controller or processor, what's their reputation, what's their history in relation to keeping data secure, which countries is data flowing to, how are they protecting that data, are you able to see their TRAs, are they able to give you other reassurances about the level of protection of the data, what would happen if everything goes wrong, how would you be informed of a data breach, look at the contract terms, look at the limits of liability, have they accepted enough responsibility for looking after your data, or are the limits set so low that actually you can't be sure that they will be keeping it securely. Think about onward transfers. That's always a difficult one. It might be, and the ICO's done this sometimes, is that although we have no responsibility to do a transfer risk assessment, we've still conducted something along those lines to give us that reassurance about the data flows. You can always add to the contract terms if you want to improve the level of protection, or of course you can reduce the data or add extra security measures in. So the next step, step 5. So the next challenge you have is whether your importer is willing to enter into the IDTA or the addendum. You know, often I'm aware that the addendum will be part of standard terms, but not always the case. The IDTA, we made a real effort to write that in plain English, so it could be an attractive option if, you know, for a importer that's new to these kind of contracts, because it's written in a really simple way that hopefully is easier for them to understand, even if English isn't their first language. There are occasions when it's not going to be possible to get them to sign up to the IDTA or addendum. And so you then have to think, well, what are my alternatives? Because I still really would like to make this cross-border transfer of data. So you shouldn't just give up. You should look to see if they will agree to any protections. You know, will they agree to some of the protections in the IDTA or addendum, but not all? You can also look to see if you can rely on an exception. Now, one of the points in our guidance is we don't think, and this follows UK case law, there's a hierarchy between the different ways to make cross-border transfers in Chapter 5 of UK GDPR. Of course, if you've got inadequacy regulations over a country, that's what you're going to use. But if you are going to rely on an exception, it has to be necessary and proportionate to rely on that exception. And if it is possible for you to put in place an IDTA or addendum, then it's much less likely to be necessary and proportionate to use the exception. And it could be, it will just take you a bit longer to negotiate the IDTA or addendum to put that in place. If that's the case, it could be that you could rely on the exception for a short period of time, maybe with some other protections in place. And of course, there is always the option of not to send the data at all. So my final practical tip is, what is the scope of your TRA? The first point that I've made on the slide is whether you can take steps so all the data is low risk. If you've looked at our transfer risk assessment tool, you will see that if data is all low harm risk, you don't need to do extra checks on the country it's going to. You can just send the data. We also set out in our tool different levels of investigation, depending on the level of risk in the data and the kind of organisation you are and your resources. Level 3 investigation is the highest form, where you have to do quite a detailed review. If you're not able to do that, if it's not cost effective, you might be able to combine doing a level 2, a much more straightforward investigation, where you just need to really look at the human rights record in the other country, and then maybe rely on an exception for your higher harm risk data. If you are doing a transfer risk assessment and it's a level 1 or level 2 investigation, our practical suggestion is you sort of sit down and you have a good think about the human rights risks in the destination country, and you ask yourself if the way that the data could possibly be used in that country by the recipient or by others will significantly increase the risk of a human rights breach to that individual. And when I'm doing these transfer risk assessments for the ICO, it's quite trite to say it, but it is helpful to imagine it's data about you or your family, to bring it to life, to make you think this is somebody's data that is going to this person in this country. Does it have the right level of protection? I've done a very quick example to run through based on some facts that came across my desk fairly recently about one of our executive team that wanted to go and do an international conference, but to be honest, it wasn't quite these facts. So we have a trans employee who's keen to speak at an international conference. So their name is the name that they're known as is different to the name on their passport, and you need to send the passport details for the flights and hotels, and they're going to be using the pronouns they, their on their speaker biography. But the human rights record for LGBTQ+ is very poor in the country where the conference is. So the key question that I would be asking is, by sending this data, will I be significantly increasing the risk of harm to them? And you can see in that scenario that there are some risks there, and you might need to think a little bit harder about whether it's okay to send this data, and perhaps even whether it's okay for this employee to go and speak at this conference. But if the conference is optional, there is a route through where you can consider discussing this with the employee, and you might be able to use consent just for those categories of data where there is a high harm risk, and then you could use the IDTA and the addendum, or the addendum for the rest of the data which is flowing. Now, I know with employees that consent is problematic, but in this situation, if it's genuinely optional, because you could find that this person regularly visits this country, regularly speaks at this conference, and they're very comfortable and they understand the risks, and you wouldn't want to stop them going without speaking to them and seeing if this is an option first. So it's probably common sense. So finally, moving on to looking at transfers under the US data privacy framework and how this is going to make your transfer risk assessment for transfers much easier. Now, the DPF data bridge is obviously relevant when your recipient has signed up to the data privacy framework, and that's quite straightforward. You can make transfers to that to those organizations freely, but it's also really helpful for the millions of other organizations in the US that are not signed up to the data privacy framework, because in order to set up the data bridge, the UK government's carried out a detailed assessment about whether the DPF provides an adequate level of protection, and I put in the title of it, which is the analysis of UK extensions to the EU-US data privacy framework. And now the analysis covers whether the DPF set of rules for processing personal data provides adequate protection, but it also goes on to look at whether, if data is shared with a public authority outside the scope of the DPF, whether the US legal framework provides adequate protections for data subjects. That framework also applies to data received by any US organisation under an IDTA or addendum, which is then accessed by a public authority. So we've been looking at this analysis, and we are going to be producing guidance very soon. It's in draft. So our view that it is reasonable and proportionate for UK organisations to rely on this DCIT analysis in their transfer risk assessment for any level of investigation, whether it's level 1, level 2 or level 3. If we could just go to the next slide. It's quite a long document, but if you are sending data regularly to the US, it's probably worth a read at least once. I've just picked out 3 of the key quotes. There will be more in the guidance that's coming. So DCIT considers that the US respects and maintains the rule of law in its constitutional and legislative framework, and that the US respects human rights and fundamental freedoms. DCIT is also satisfied that when US authorities access data for the purposes of national security, they do so in a manner provided by law. I won't go through all of it, but I'll go on to the next one. And then the US system is underpinned by robust limitations, safeguards, oversight and redress mechanisms in relation to law enforcement access to personal data. And DCIT's content that the protections available for UK data subjects are not undermined when their personal data is transferred to the US. So that can be the basis of your investigation into the country, into the US, when you're sending data there. You do still need to do some kind of transfer risk assessment, because we do have that Schrems decision that says when you send data using the SECs or the IDTA or the addendum, you do need to have done that assessment, but it can be super straightforward, and we're trying to work through that in our guidance as to how straightforward it could be. The guidance that I can give today is that, you know, there's no need for you to assess the level of risk in the data for your transfer risk assessment, as your assessment's going to be the same even if it's very high harm risk data. You will need to put in a statement somewhere that you are relying on the DCIT analysis for your transfer risk assessment, and you'll need to keep this under review in line with your other IDTA addendum reviews, in case, of course, the DCIT analysis changes. But apart from that, it's job done for transfer risk assessments to the US.
That's great. Thank you so much, Emma. We really appreciate your insights on that. I do have a series of questions that have come in, as I'm sure you anticipate, while you were speaking. So what we'll do is we'll hold those to the Q&A session at the end, but for anyone who's already asked a question, thank you so much. Please do keep them coming in. And as I say, I will then MC a Q&A session after John has finished speaking, which leads me neatly into John's presentation.
Thank you very much. Yeah, thanks, Emma. That was yeah, really interesting, and yeah, glad to see questions coming in that already. And I suspect we're only going to get more because I know it's something that a lot of our clients are interested in. You know, it's a difficult area for people, difficult area for legal within business to cope with. It seems to be like an ever-changing landscape, which creates a bit of frustration for some. So I think guidance and a bit of certainty on this is going to be, you know, welcomed for all of our clients. So yeah, very quick introduction. I'm John Timmins. I'm a partner at White & Case in London. I cover data protection and cybersecurity. And today, what I'm going to chat through is some of the recent developments in the data protection space affecting businesses in the UK and those with a slightly broader jurisdictional footprint. So thinking about those who are operating in the UK and the EU. You know, it's been a little over 5 years since enforcement of the GDPR began, and just a few years since the UK GDPR took hold here in the UK. And in that time, we've seen a sort of continued evolution of the law and the practice in this space, and it's impacting businesses that are processing personal data, which is more or less all businesses. I think it's safe to say that what we have seen is that most businesses, if not all, although probably not all, have navigated through the relative chaos of getting to a comfortable compliance position with the GDPR. In the run to 2018 and the year or so afterwards, it was slightly chaotic for a lot of organisations trying to figure out what they needed to do and where they needed to be. And I can say with almost absolute certainty that there is no appetite for businesses to go through that process again to comply with the UK position, UK GDPR. And I think that's why, as we'll come on to talk about, it comes as sort of welcome news that the proposed changes to the UK data protection legislative framework are a bit more of an evolution of the practice. They certainly don't really go beyond what's required in the EU, and in some cases there's a bit of a relaxation and a reduction in the compliance burden. So I think that's going to be welcomed. I think it's also just worth saying at the outset here, we have started to notice a bit of divergence in practice between the UK and the EU in the data protection space, but also in other areas which are related to data protection, such as cybersecurity, which for the time we'll touch on very briefly. And I think it's just one thing to keep on people's radar. So legal within organisations, I think, just have to be mindful of the fact that there are changes afoot. The direction of travel is slightly different. The UK, I suppose you could say, is still in orbit with the EU and the EU GDPR position, but there are different destinations, I suppose, being looked at by the UK and the EU. So to start with, what I'm going to discuss is some of the more notable changes, I suppose, as I see them, proposed to the UK data protection law by the particularly titled Data Protection and Digital Information No. 2 Bill. So if we move to the next slide, please, Tim. Yeah, so and maybe jump on one slide and we'll come back to this one in a second. So what, why, and when? Well, if we start with what it is, maybe actually let's start with what it's not. It's not a piece of legislation which helpfully streamlines UK data protection law into one neat document and puts it all in front of you in an easy to read format. It's definitely not that. It's a sort of typical UK piece of legislation that amends the existing law and is a delight to read in the wee small hours of the morning. Some had anticipated, I think some had probably hoped for, a more of a significant change to UK data protection law post-Brexit, and that anticipation was probably most acutely felt before the publication of the first version of this bill. But after publication, it became quite clear that actually what the UK government was focused on doing was introducing some targeted, specific, but significant changes to the legislation with a focus on trying to reduce, where possible, compliance burdens for organisations, particularly small to medium organisations. And I know that in the most recent, I suppose, version of the bill, the No. 2 bill, which we're going to talk about today, before publication of that, I think some again had hoped for maybe a bit more of a rewrite, a bit more of a tidying up and streamlining of some positions, but that's ultimately not really what's happened. I think what's quite clear though from all of it is that the UK government's position has been constrained by a view to adequacy. So and that is referenced in a lot of the debate around this topic. There is only so much that the UK government can do within data protection law in the UK before it starts to create a problem for itself on the legal front with respect to adequacy. I'm not going to talk a lot about adequacy today, but we all know that adequacy is both a political and a legal issue. And ultimately, you can make the politicking much easier if your legal position is relatively sound. And I think what the government has done is essentially looked at the law, figured out ways where it can make changes without really upsetting matters too much. So there's not a huge amount of room to manoeuvre, and that's reflected in what we've ended up with. So it's a targeted, arguably quite a nuanced approach to amending the legal framework. And it is focused on the British economy and British businesses. I mean, the Secretary of State in the explanatory notes accompanying the recent bill, I think, mentioned the fact that the UK economy could receive a boost of up to £5 million as a result of this legislation. I suppose we'll maybe just have to wait and see on that one, but that gives you an idea of sort of what they're thinking about. In terms of why it's needed, if we jump back a slide, we can see what the government said in its explanatory notes when it published this bill. And the focus is clearly on getting rid of barriers, uncertainty, unnecessary burdens for businesses and consumers. I mean, one could take each of those points, barriers, uncertainty, and unnecessary burdens, and I suppose challenge them. But why it's actually needed? That's the government's perspective. I mean, arguably, it isn't needed. I mean, the UK could continue on as is. It could have continued on with the UK GDPR and the Data Protection Act 2018, and it could be argued there's no real need for the bill. But that said, I'm speaking personally, I mean, anyone that has any familiarity with the GDPR probably would have hoped for someone to come along and done a bit of a rewrite of that legislation, tightened it up and clarified bits of it. But unfortunately, this legislation doesn't do that. What this legislation does do, as we've said, is create a framework for UK-based businesses to have a bit more flexibility and a bit more room to manoeuvre around the edges of data protection law. So, why it's needed? Well, the UK is setting its own course in this field, and this legislation helps UK government to do that. And then in terms of when, I mean, it's hard to say. We thought maybe H1 2024. That might slip. We're heading into an election year, or probably an election year. So we'll just have to wait and see. I mean, the next 12 months, maybe. The next 24, I guess, probably. But I think it's just a case of watch this space. So now to just pick a few points of the legislation, which I think are worth noting and just bearing in mind as the law sort of develops through Parliament and continues on. The definition of personal data has been amended by the UK bill. Now, what is personal data? I suspect everyone that's on this call probably knows or has at least some idea of what personal data is. But I mean, ultimately, it is the cornerstone of data protection law. So, in order that for the UK GDPR and the EU GDPR to be applied or be applicable, there needs to be some processing of personal data. So, on that basis alone, it is incredibly important that organisations have a very clear understanding of what is and what is not personal data. And you look at the EU GDPR definition of it, and it is very, very broad. I mean, it's quite literally any information that relates to an identified or identifiable individual. So, it is not constrained by sort of time or place. It is an open-ended and expansive definition that captures a lot of information. Now, the UK position, next slide, yeah, is slightly different. The proposal would have the effect of slightly narrowing the definition of personal data. And what the UK law or the UK bill focuses on is on the idea of whether information relates to an identifiable living individual. So more specifically, what the law is saying is that an individual is identifiable if they are identifiable by the controller or processor by reasonable means, being those that the person is reasonably likely to use at the time of processing, or by another person that the controller or processor ought reasonably to know is involved in some way. What's interesting about this is that it constrains the number of people that a controller has to think about when determining whether or not a set of information it has is personal data or not. And so you can look at who are the people in orbit, who's the controller, who's the processor, who are the people that are likely to be involved in processing this personal data, and what are the means available to those entities at this moment in time for processing that personal data, or that information, let's call it, to determine is that information personal data. So that is a narrowing of the definition. It makes personal data a slightly smaller and a slightly, maybe arguably slightly more specific category of information than is set out in the EU GDPR. And this change is interesting. I mean, it would arguably exclude. I mean, if you read what the legislation says, it's not on these slides here, but if you read what the legislation says around identifiability of information or personal data, it talks about the reasonable means that are likely to be used, and it talks about, well, what is the cost involved, what's the resources involved, what's the time involved to use information to identify a person, and you use that criteria to figure out if it's personal data or not. And so you could have a situation where you have a body of information, there is a technical means to identify people from that body of information, but in your specific circumstances, it's maybe unlikely that you're going to do that, and you sort of create a record around that. That means that information is technically not personal data. So, it is quite interesting how this is going to play out in practice, and what this will mean for different organisations processing personal data at different points in time. But it could result in a situation where, essentially what would be personal data now is no longer personal data, which would give organisations, greater scope to use that data for, interesting purposes, maybe in the context of everyone's favourite topic at the minute, AI, or training algorithms or things like that, where you couldn't do that now, or it would be much more difficult to do that now. So, as you can see in this screen, I mean, I think one of the other byproducts of the amended definition is that it could make legal anonymization easier to achieve. I mean, technical anonymization of data is, near enough impossible, but you can follow the law through and the wording of the law here, and probably get to a position where anonymization is slightly easier to achieve under the UK proposal than it is under the GDPR. And again, that means you can have some information that will fall outside of the scope of the law, and there's wider use cases for data. I think one of the I suppose more challenging points here really for businesses, particularly multinationals, is, well, what approach do they take, right? So the UK has a slightly different definition of personal data from the EU, arguably slightly narrower, slightly more constrained. But my view, I think, is that most organisations will just start from the position that, okay, well, whatever we consider personal data under the EU GDPR, we're just going to apply that across the board. And I think to start divvying up what is personal data in the EU versus the UK for an organisation that is across both jurisdictions could just be a time and effort better spent elsewhere. That's not to say that position might change. So what we might see after 4 or 5 years of the law in place, and maybe see particular benefits being derived from the UK position, you might start to see multinational businesses look at siloing their approach in the UK, or having a UK specific focus so they can benefit from the adopted legislation. But I think in the first case, I think what you'll probably see is just a lot of organisations continuing as is, and not trying to narrow the scope too much for the time being. So if we head on to the next slide here. So one of the other changes we're going to talk about is the approach to DSARs under this legislation, or the proposed legislation. UK data protection law grants all individuals the right to request a copy of their personal data. As simple as that right is to state, and as simple as the request is to make, compliance is a completely different story. And I think anyone that has any experience of managing or responding to DSARs knows how time-consuming, complicated, resource-intensive it can be, and how much of a drag it can be in an organisation, depending on the nature of the request, when it's received, and even the underlying purpose. You will have heard, I'm sure, talk of the weaponization of DSARs and how these are used to tie up organisations where an individual doesn't want a copy of their personal data, they just want to create a bit of a nuisance. And the position around that has been difficult to push back on. I mean, under the GDPR and the UK GDPR presently, the threshold for pushing back is that the request has to be manifestly unfounded or manifestly excessive. The new approach being proposed is that if a request is vexatious or excessive, you can push back. Now, what does that mean in practice? Well, it gives organisations slightly more scope to push back. I should say what's set out in the bill isn't a million miles away from what the ICO guidance says on DSARs and managing and responding to DSARs. So there is already scope in the law for pushing back. But what this does is it enshrines in law certain channels for pushing back that I guess previously were a bit more unclear. So if you receive a request that is intended to cause distress, or is not made in good faith, or it's an abusive process, so someone's stepping outside the litigation process, then you can push back on the basis it's vexatious. And so this is interesting for organisations, I think, that are going to be receiving DSARs under the UK law, but they'll be able to maybe peek behind the curtain slightly, have a bit of an assessment of the purpose being pursued by the person seeking to exercise their Article 15 right, and then potentially push back on that basis. So again, it's not a huge change or a huge move away from the current position, but it is a notable one, and it is one that will give organisations potentially a degree of freedom that they don't have at the moment. So the next thing we're going to talk about briefly here is the legitimate interests under the bill. Now, legitimate interest obviously is one of the legal bases for processing under the GDPR, and it offers a degree of flexibility, but it's not without risk, and it has challenges when organisations try to rely on that. And I think we can see that from decisions of regulators and decisions of courts when legitimate interests as a legal basis for processing has been put to the test. If you want to rely on legitimate interests when processing personal data, you really have to undertake a legitimate interest assessment at the outset. So you have to work out, okay, what legitimate interests are we as an organisation pursuing, and what personal data is necessary to be processed in the context of pursuing those purposes. You then have to balance that against the interest, rights and freedoms of the individual whose personal data you are processing. So far, so good, I guess. Shameless plug, engage, data protection lawyers to help with this process, or at least have data protection specialists within your organisation that can do the LIA. You can develop a really robust position at the outset, setting out very clearly your position, your assessment, your interests. Have that all set out, because if an individual comes along and challenges you, or if a regulator comes along and challenges you, you're going to have to produce this document and show that you've done the thinking and that you're able to justify your position. And even then, there's no guarantee that you're going to be able to rely on it. It's just that you're in a better position in that situation than you would be if you'd done nothing or done very little. So I say all that to sort of introduce how the bill approaches this. What the bill does on legitimate interest is it sets out a list of sort of non-exhaustive examples of when it may be appropriate to rely on legitimate interests as the legal basis for processing. And those include direct marketing, intragroup transmissions for internal admin purposes, and ensuring the security of information systems. So this is helpful to an extent, because what it does is it brings into the body of the legislation itself examples of where legitimate interest may be appropriate, it gives a bit of clarity where there maybe isn't any at the moment under the EU GDPR, and it shows where, okay, these are where you might be able to rely on this as a legal basis, which is helpful. But again, it doesn't do away with the fact that you still need to do an LIA. It doesn't do away with the fact you still need to do this this thinking at the outset before you rely on legitimate interests. But then on top of that, as a separate category of legitimate interest, you have this recognised legitimate interest category. Now, this is an expansion on the legal basis available for organisations, and what this says is you can process personal data for one of the recognised legitimate interests, which are all public interest type processing. So as you can see in on the slide there, it would include things like emergency response and, clumsily written by me, crime. Now, that's not processing for the purposes of committing a crime. That's processing in the context of detecting or apprehending criminals, things like that. So those are the examples where you can rely on it. And when you're processing for a recognised legitimate interest, you don't need to do the balancing test. It's presumed that you're okay in that front. Interestingly, though, you probably would still have to do an initial assessment when you're engaging in that processing to figure out, well, is the personal data that we're processing necessary in this context? And that, similar to the point that Emma has made in the context of international transfers, you have to work out, well, actually, the data we're sending, do we need to send it? And is the processing of it necessary? The same here, I think, where you would say, okay, we're going to process this data for this purpose, but and it's recognised as an interest, so we can do it. But we need to ask ourselves the first question, which is, what data is actually necessary in this context? Because if you're processing more data than is necessary, then there's going to be potentially a compliance issue there. And then other significant changes. I mean, it's a long list. We could sit here all day and chat about this, although no one would thank me for that. So I won't do that. But this gives you a flavour of some of the things that are changing. And some of these are maybe more material than others. I think for smaller organisations, the change to records of processing activities is quite an interesting one, where you're only going to be required to maintain those for high risk processing. That I find interesting because there was a lot made about this as a thing, taking away some of the bureaucracy around data protection compliance. But actually, ROPAs, for all the headaches they cause, they're a very helpful document, right? I mean, they help organisations figure out what the processing activities are, and then help them map compliance practices around that. So whilst they might not be technically required in certain circumstances, I think probably still quite useful. And then other changes, things like automated decision making. The rules on that are now only going to be engaged where there's no meaningful human involvement in the processing. So there's scope for more automated decision making processing to take place under the UK proposal than would be otherwise. And yeah, and then like I said, there's a whole bunch of other, I suppose, important changes, but maybe not as significant as the others. So in the time we've got left, we're going to sort of very quickly, speedily run through some of the developments in the case law, just to flag some developments here. So on the damages front, I think a couple of points worth to note. Lloyd and Google and the Post AG case show that a sort of degree of continuity between the position in continental Europe and the UK, in that a violation of the GDPR or the UK GDPR in and of itself is not grounds for individual to claim compensation. There has to be some link between the violation of the law and the harm or damage suffered by the affected individual. If you can show that causal link, then you may have a claim. The range of damages is quite wide, and we've had cases in the UK as low as £250. You've had other cases more recently where it's been £3,000 in awarded damages. So, but both courts here and abroad seem to be relatively aligned on that for the time being. On access, we'll start with the bottom case. This is another Post AG case. This concerns access to information about recipients of data. So under Article 15(1)(c) of the GDPR, you're entitled to a data subject to ask for information on who are the recipients of personal data that have been processed. But the law actually says categories of recipients or recipients, and many controllers have viewed this historically as well. If we can provide categories of recipients, that's enough. What the law says now, or the case law says now, is that won't be enough. If an individual asks for specific information on recipients, except in specific circumstances such as where it's impossible to do so, the controller has to hand that information over. Now, we don't have UK case law on that at the moment, but given that the provisions of the law currently are identical, I think that case would probably be quite persuasive in a UK court. And then the transcription agency in Master James' case above is interesting only because it's a bit of an outlier in terms of what it says on access requests. So whereas we're sort of all trained to believe that when you look at a DSAR at the moment, it's purpose blind, individuals can make DSARs for whatever reason they wish, and really, except in exceptional circumstances, you can't query why they're doing it. This case law kind of goes against that slightly, with comments in Overtur which say that essentially the Data Protection Act 2018 and the GDPR can't be used kind of to get around procedures that are in place otherwise, or to get around issues in litigation. So it's interesting, but it maybe points towards a slight divergence there. And then I won't say much about cybersecurity landscape other than to point out that the UK approach to cybersecurity is materially different now from the EU position. The EU has introduced new legislation in this field which expands the number of organisations within the scope and increases their obligations. The UK proposal is much more pared back at present. That's obviously subject to change. So just to really quickly wrap up, I think the key takeaways from all of this are that if you're an organisation that I guess is multi-jurisdictional, your UK and EU, you may lose out on some of the benefits initially of the UK changes, because you'll probably be pursuing the path of least resistance. So you'll want to just take an approach that doesn't require you to rethink everything that you're doing. If you can comply with the EU GDPR and that more or less gets you there for the UK, then I think you probably do that. Wait and see how things play out, see what the UK landscape looks like, see if there are things to be benefited from under the new regime, and then make a call. I think the people that are going to benefit most are UK focused businesses or UK siloed businesses that are really only exposed to the UK data protection law, and they can really hone what they do to fit around the legislative requirements, and maybe sort of reap the rewards of the reduced compliance burdens and the slightly more flexible regime. So yeah, I won't say more than that. That's been a pretty quick run through, and thanks so much for paying attention, if you did.
Thanks so much, John. That was great and super informative. I have a number of questions here asked by members of the audience, but I'm going to start with a perhaps overarching question, which is, we've talked a huge amount about the number of changes that have been going on. So I have a question for Emma and for John, which is focused really on the consequences of those changes. So we've seen the UK and the EU developing their own similar but slightly different transfer mechanisms. We've obviously seen all the changes that John has just talked about, including the UK essentially rewriting chunks of its data protection legislation, and perhaps most importantly, the change around the definition of personal data, right? Because the Court of Justice of the EU made it pretty clear in the Breyer decision that if personal data is personal data in anyone's hands, even if it's a third party that can, by any reasonably foreseeable means, identify an individual, whereas the UK seems to be drifting much more towards, well, can the controller or processor identify that person? So my sort of opening question is, to what extent do we think that the UK's adequacy decision is at risk, given that the UK does seem to be materially diverging from the EU on some of these issues?
So I'm just trying to, it's not, do we think the question is, do we think the UK's adequacy is at risk? And I'm hesitating because it's not something that's a risk that is, from an ICO perspective, it's a risk that's managed by government, not by the ICO. It's something that we are aware of and that we are conscious of. And I know that also DCIT and the UK government are also very aware of and very aware about that balance. But I would say that you don't, there are many countries with adequacy decisions from the EU who do not have it, who don't have identical regimes to GDPR. So I think you can overstate that risk every time we do anything that's slightly divergent from the EU. But you have to bear in mind that there are many other countries which didn't start from the same place which we did.
Yeah, I think that's a very sensible way to look at that.
Yeah, I mean, I agree with that. I also think that, like I mentioned when I was speaking, I think there's the legal side of it, right? I mean, you can look at the legal test for adequacy, but I'd say just as important a piece is the political side. There will be political aspects to those decisions at any given moment in time. It could be used as leverage, and so I don't think adequacy is at risk at the moment. But if you look at the reasons why the US has struggled for so long, a lot of those issues are present under UK legislation. So I think it's just a risk that's always there, and I think the thing that will move the needle, unless the UK goes completely off-piste with its data protection legislation, I think the thing that will move the needle there is a breakdown in political relations between the two blocks.
I think that's probably fair. So Emma, the next, I'm going to combine two questions here because they're kind of asking about the same thing. So you made the point earlier that if you're a UK company and you engage a UK service provider, and the UK service provider then engages a sub-processor outside the UK, that you as the UK company don't need to worry about implementing a data transfer agreement with your UK-based processor, but the processor then obviously has transfer obligations of its own. And then a similar question here is about what if I engage a sub-processor in a country that's not the UK, but is, or if I engage a processor in a country that's not the UK, but is adequate, and they then transfer the data to a sub-processor in a third country. So it's kind of the same question. That what they're really asking for is, what do I as a UK company need to do about onward transfers by my processor?
So I think rather than it falling under Chapter 5 of UK GDPR, technically it falls under, you would be looking at whether it was necessary and proportionate under your lawful basis in Articles 5 and 6. But more practically, I think it's about due diligence, and I think it's about thinking about the risk in your data and thinking what are reasonable and proportionate steps for me to take to check on whether I think that it's is it okay for me to be sharing my data with this controller? In some situations, it could be that you think it's reasonable and proportionate to have looked at the contract, looked at the kind of recipient. I mean, if, for example, if they are a highly regulated organisation where you can have a high degree of confidence in how they handle data, you may not need to do that much due diligence at all. But if it's a smaller operation where you're not confident as to how they, how they will themselves have conducted their own assessments and transfer risk assessments, and then you might want to do a bit more due diligence on it. But I hate to be in the it depends category, but there is some due diligence to do. You should be doing due diligence now anyway when you share data, and it's just replicating that, but with also thinking about how they've carried out their transfers and onward transfers and what protections are in place. And as I said, sometimes at the ICO we have done our own mini transfer risk assessment even when we don't have to, because it helps for us to frame and understand what the risks are.
Thanks very much. We have a terminology question here for those of us not familiar with the functions of central government. What is DCIT and what does it do?
Oh, sorry. That's a hard question. It should be. So it's the Department of is it? It's the department that's responsible for data protection, but is it? I'm trying to think what the S is. Is it Science, Innovation and Technology?
I think so. Yeah. And it's liaising with the ICO in this context.
Yes. So we work quite closely with DCIT. So it used to be DCMS, and now that's when there was a shift around, it's now DCIT, and we do. Most of our work is with DCIT and the Home Office. So Home Office in relation to law enforcement processing and other kinds of processing, and DCIT is our sponsoring department for all things GDPR.
Thanks very much. There's one here that I think I can hopefully address. Someone has asked, is sending people's contact details, so their work location, phone number, email address, within the UK and the EU a breach of personal data law? I think the answer to that question is no. You are entitled to send people's personal data to other jurisdictions. It's just that, as Emma has very clearly explained, we need to make sure that we've got appropriate protections in place before we engage in that transfer. So we need to figure out, are we transferring something that constitutes personal data? And as John has said, we've got slightly diverging but still pretty similar definitions of personal data in the UK and the EU, assuming the number 2 bill is passed in something like its current form. But in either of those definitions, a person's name, phone number, workplace, that kind of thing are going to be personal data. So then you need to talk about, well, am I transferring this outside the UK? Looks from the question, so the answer is yes. And then we need to think about, well, if I'm going to transfer personal data out of the UK, have I done, as Emma said, appropriate due diligence on to whom am I sending the data, for what purpose? And if I have, do I then have an appropriate transfer mechanism in place? If I'm in the EU, have I implemented standard contractual clauses? If I'm in the UK, have I done either an IDTA or the UK addendum to standard contractual clauses? And then in addition to that, have I done my TRA, my transfer risk assessment? Have I looked at what risks am I creating? There was one further question, but apologies, we are at time, so I'm going to call it there. But thank you so much, everybody, for attending, and thanks once again to Emma and John for their very thoughtful presentations.